Sidharth Luthra is someone who practices in the Supreme Court. He's a senior advocate. Mr. Luthra, what's your view on this? Many Supreme Courts, maybe 4, maybe 5. By the looks of it, on paper, it sounds like a sound idea.
Actually, we must understand that when the Supreme Court was constituted, it had to, by and large, sit in its complete strength, which was 6, number of judges was specified, and now we've increased it to 34 judges. But what's really happened is, from the late 60s onwards, 70s perhaps, the numbers of matters in the Supreme Court increased. So judges started sitting in benches of 2 and 3, as a result of which that the larger bench strength determinations stopped happening, except when constitutional benches were framed or created for the purpose of listening to specific matters. Now that's a change. So our court in that sense is not just a constitutional court, it's an appellate court. It's an original court where it deals with things like PIL, let's say clean air, water, etc., human rights, health rights, so all of that. And it's also a court where you have a lot of statutory appeals coming, let's say, from the competition tribunals or from the tribunals related to telecom tribunals. So all of these have created a court which is now no longer purely a constitutional court. In fact, even the Constitution says that the seat of the Supreme Court doesn't say the seat of the Supreme Court will permanently be in Delhi, but that the Supreme Court will sit at Delhi. There was never any issue about the Supreme Court sitting at any other location. So let's understand the constitutional issue. Now the question really is justice delivery going to be enhanced by creating regional benches? Now there are two arguments for that. On the one hand, in the pre-COVID era, in the pre-video conferencing era, before courts started hearing matters through VC, it would have made sense to do this. Today, the fact is, if we were only to enable the hearing of matters through VC more, if we were to ensure that not just on Mondays, Tuesdays and Fridays, but any other day, throughout the day, lawyers can appear through video conferencing and assist the court, I think there will be no concern at all in achieving what we desire to achieve and with no extra cost. Because the point really is, we're e-filing, for which physical presence is not needed. We have video conference hearing. When we interact with clients, by and large, we do it through VC. And therefore, if that was to replace the physical form, perhaps we may reach a stage where judges will end up doing their hearings from their residences as they had done during the COVID era, and we will not even need such large physical infrastructure except for maintenance of records. So that's one point. The second thing is, will it weaken the court? To my mind, I think it would have been an ideal situation if rather than creating just regional benches, we would have gone back to what is contemplated, create a constitutional court and then have an appellate court which is one level below. Like, for example, in Australia, you have the federal court, or in England, you have the Court of Appeals in some countries. So create an intermediate court between the High Court and the Supreme Court. Leave issues of constitutional importance alone with the Indian Supreme Court and let all the appeals go to the appellate court. And by and large, they should be determined. That's the second thing I would have desired. So far as the numbers are concerned, let's understand one thing. Why do the numbers, you talked about 80,000 pendency. Let's understand why there is a pendency. The point is, go back to the 70s, 80s. In bail matters, and we were liberal about bails, the high courts were the last court. Against interim orders, the high courts were the last court because matters used to be determined at a faster pace in the trial courts and even at the high court. Today, the fact is, bail matters, and this is unfortunate, need to come to the Supreme Court so very often. Prosecutions are filed which are frivolous. A civil suit is filed, an injunction is taken that does not see the light of the day for 20 years, and therefore people are really warring on the interim directions or interim orders, and there's no determination. So when we want to look at the system, we have created a top-heavy system. We need to revisit it.